Imagine you are involved in an exciting event or a new professional opportunity, having signed an agreement that you believe clearly outlines everyone's responsibilities. But what happens if that agreement, especially a waiver of liability, is later challenged and found to be unenforceable? The enforceability of a waiver is profoundly impacted by jurisdiction, meaning the specific state or country whose laws govern the agreement. This means a waiver considered valid in one location might be completely ineffective in another, due to differing legal standards and public policy considerations. Jurisdictions vary significantly on what they requiring for a waiver to be legally binding. For instance, some demand very specific language clearly outlining the types of negligence being waived, while others might focus more on the conspicuousness of the waiver, ensuring it was not hidden in fine print. Each state has its own unique framework concerning contracts and liability, which dictates the scope and limitations of what can be waived. Key factors include clarity, specificity of the language, whether there was adequate consideration, and if the waiver addresses ordinary negligence versus gross negligence or intentional harm. Understanding these differences is crucial for anyone drafting or signing a waiver. To practically navigate this, always identify the governing law specified in the agreement, which indicates the jurisdiction whose rules apply. If no governing law is stated, the location where the waiver was signed or where the activity took place often determines the applicable jurisdiction. Remember that laws are not uniform. A one-size-fits-all approach to waivers simply does not work. Beyond the general legal standards, public policy plays a massive role. Many jurisdictions have deeply held public policies against allowing parties to contract away liability for certain types of conduct, especially when it involves minors, essential services, or activities where there is a significant power imbalance. For example, some states will not uphold waivers signed by parents on behalf of their minor children for negligence claims, while others may allow it under very specific conditions. This public policy concern ensures that a party cannot simply avoid all responsibility, particularly in situations where it might endanger others. Ultimately, the validity of a waiver hinges on meticulous attention to the specific legal landscape of the relevant jurisdiction. By understanding that a waiver is not universally enforceable and that its strength is tied directly to local laws and public policy, you can better assess risks and protect your interests, ensuring your agreements actually provide the intended legal shield.